Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Has the Commission had an opportunity to review last month's draft minutes? Is there a motion regarding approval?
Move to approve. I'll second.
All those in favor?
Aye.
Motion passes. We have a lengthy agenda today. The first item we have is under public hearing. We have our annual emergency record zone assignments public hearing. I understand that no applications or alteration requests have been filed, though. Mr. Fields?
That's correct. The Commission by ordinance is required to have an annual meeting to consider any applications or changes to the emergency record assignments. There were none, but it's appropriate to actually open a hearing, hold the hearing. Again, there's nothing to consider, nor could you accept any at this particular meeting because they missed the deadline that you had established. I have invited the emergency record company. Some of them I think are here. They may want to speak to the Commission since it is their annual meeting.
Has anyone submitted a formal request to speak?
They did not, but because it's their hearing, we typically don't ask for any.
Is there anyone who would like to speak as part of our public hearing on this issue of the annual emergency record zone assignments? May come forward, please. Good afternoon.
Good afternoon. I'm Jim Mitchell with West Nashville Record Service and Dad's Towing, and we are requesting a change in backup in a couple of the zones. It's not a zone change, but it is a change in backup. We have spoke with both the zone companies and requested them to allow us to do this due to the fact that the A.B. Collier was transferred. We, of course, lost quite a bit of revenue at West Nashville, so we've requested that Bailey's be transferred to West Nashville just to backup for heavy only, and that Custom be transferred to West Nashville for the backup for the heavy only. Well, they backed themselves up in light duty, so we're requesting backup for the heavy to be transferred to West Nashville. Also requesting Chapman's as a small area to be transferred to backup only for heavies to West Nashville Record.
Mr. Fields, is it appropriate to consider requests to change backup?
Actually, the backups are not subject to public hearing that I'm aware of. It is appropriate for them to bring that in front of the Commission for the Commission to consider. Staff, it's my understanding, and we've not made any changes in the last 6 years, but it's my understanding that staff typically works with the industry to establish how the backups happen, especially in the heavy. As today, we only have two companies that are doing two entities that are doing the heavy towing in Nashville, West Nashville and Dad's, and then Cotton's Tow Pro and A.B. Collier as a group. So we have those two operators are doing it. So since we'd had three, we're down to two. So I think what Mr. Mitchell would say is, since it's gone from 3 to 2, we should probably reconsider as a staff who's backing up who. What we would do is work with the police department and the emergency communications center to make suggestions. If again, I can't find in recent history where the Commission dealt with it, but we could put together a plan and bring it back to the Commission for your consideration.
I think that's a good idea.
Okay.
Thank you.
Other than that, that's all I have. We appreciate allowing Dad's in West Nashville to perform the duties of the zones, and we thank you for your appeal.
All right. Thank you, Mr. Mitchell. Is there anyone else who would like to speak as part of our public hearing? At this point in time, we'll close the public hearing. Since there have been no applications or alteration requests for actual zone assignments, is there anything for us to address?
I don't believe there's any action that you need to take. Well, you could affirm the zones that are in place. That might be appropriate.
Would anyone like to make a motion regarding the zones in place?
Will that affect what he just requested?
It would not.
Okay. I'll motion to approve the zones as assigned. Is that?
Second.
All those in favor?
Aye.
Motion passes. We also have a public hearing on our review of the Transportation Licensing Commission Administrative Rule. We have a proposal for us to amend that rule. Mr. Fields?
What we'd like to do is amend the rule that would require all complaints be filed within 30 days of the event. We had one that was several months old last year that we were unable, if we had needed to investigate, it was impossible to investigate. So we're asking that the 30-day, if we have a complaint, that it should be within a 30-day period.
All right. Is there anyone who's requested to speak on this issue?
I'm not.
Is there anyone who'd like to participate in the public hearing regarding our amending the TLC administrative rule to require complaints to be filed within 30 days? At this point in time, we'll close the public hearing. Would anyone like to make a motion regarding the rule proposal or discuss it?
What rule is that?
Well, it would be just a one-sentence rule that all complaints must be filed within 30 days of the incident.
So we're adding. the
Right,
rule,
would be
not
amending.
the rule?
Mhm.
Okay.
And my question was, is this including complaints, say, against a taxi driver or against a carriage
It'd be
or anything?
any
Anything,
complaint.
without any exception?
From what I understand, it is focused on complaints that are brought before the TLC.
Right.
So it could be by a tourist, it could be by a Nashville resident, it could be from another company or driver of another company against another company.
Always reserve
So
the
it-
right to
it
hear a
would
complaint
encompass
which
all.
does not meet.
And I don't doubt that company complaints against companies would be within 30 days of the incident, but my only concern is tourists or other citizens who might bring a complaint and not, or might have a complaint and not realize they can bring it to Mr. Fields or the commission, and it's more than 30 days out.
If the current rule doesn't speak directly to the time period, but what it does talk about adherence to the rule. Complaints about the public and so forth must be filed in writing, and talks about writing. Then it goes on and says that they should be 14 days prior to the commission, but the commission reserves the right to hear a complaint that does not meet the 14-day rule. So clearly the commission could say that all complaints should be filed within 30 days. However, the commission reserves the right to hear a complaint that is heard, that is brought, that happens prior to those 30 days.
And I do recognize the need to have a complaint brought timely so it can be investigated. We've run into some of that with the pedal transportation where someone changes jobs and we can't reach them anymore, but I'd be willing to try a motion. I'd make a motion to add to the TLC administrative rule proposal that complaints are to be brought within 30 days of the incident, with the proviso that the commission reserves the right to hear complaints at their discretion, regardless of when they're brought.
Second.
All those in favor?
Aye.
Motion passes. Next item on our agenda is under wrecker and towing services. We have 2 driver applications. The first is Stephen Holder, and we also have David Reed. Mr. Fields?
In making his application, Mr. Holder has applied to be a record driver. In reviewing his application, there are some incidents that are within the last couple of years that involving theft, and others that I felt like you needed to review prior to, rather than me review it. Mr. Holder, are you present? Come on.
Hello?
Hello.
Can you tell me about the two arrests that you listed on your application for theft of property? One was $10,000 to $60,000 in value. The other was $1,000 to $10,000 in value.
Should have just been one theft. It was just pled down into value because I'd returned the property.
I see. I misinterpreted your handwriting. So could you tell us about that?
I was working for company Amazon and just made some bad choices and ended up stealing from them. Returned all the property that I'd stolen and paid in restitution for the rest of what I did not have. It is currently going under getting dismissed off of my record in February 2nd.
All right, so you pled guilty to theft of property from $1,000 to $10,000?
Yes, sir.
A felony?
Yes, sir.
In 2015 or 2016? It says here May 7th, 2015. My question is, was that when you were charged or is that when you pled guilty and were placed on a sentence?
I believe it was in 2016 that this I was put on probation for it.
What county was it out of?
Murfreesboro.
Rutherford County?
Yes, sir.
All right, so in 2016, you were placed on probation for a felony theft charge.
Yes, sir.
All right, and how long was your period of probation?
2 years.
2 years. So that means 2018, you come off the probation.
This coming February 2nd.
Okay. And you must have been placed on diversion, judicial diversion, so
Yes,
you're
sir.
expungible.
Yes, sir.
So you don't actually have a conviction.
No, sir, but it does still show.
Now, 2016, August 2016, it looks like you had some drug cases. Is that
Yes,
correct?
sir.
Where was that out of?
I was just driving home from...
Oh, what county?
What county? Wilson.
All right. So you are on judicial diversion for 2 years from 2016 to 2018, and you pick up new convictions for these drug offenses?
They were actually charged at the exact same time I was arrested because I had the warrant out for the theft because I'd went to court before for it and it was dropped under the circumstance of 1 year for them to have proof that I had actually stole anything.
All right. So you got picked up on the drug cases and they found out you had an outstanding warrant and then you dealt with the Rutherford County one. What was the outcome of the drug cases in Wilson County?
Pled for attempted possession of Schedule 2.
Attempted possession of Schedule 2?
Yes, sir.
Is that a felony or misdemeanor?
Felony.
Felony. So what was the sentence?
6 years probation.
So you're on probation right now?
Yes, sir.
For a felony?
Yes, sir.
If he has a felony conviction,
all I-
he's not. I was not aware of the felony conviction. It was my impression that was diversion. That was not diverted?
The theft was diversion. The drug charges has not been diverted.
Mr. Holder, I don't think you're eligible.
He would not be
to-
eligible if I thought they were all in a diversion. You would not be eligible for a period of time, 5 years from the point of the conviction. I apologize for getting you down here for that.
Yes, sir.
I thought they were under diversion as well. I don't think you can consider the application.
Sorry.
Yes,
Would you
sir.
like to make a motion regarding the application?
I'll make a motion to decline Stephen Holder's application for wrecker and towing service. I'm sorry.
Yes, sir.
Second.
All those in favor?
Aye.
Motion passes. Thank you, Mr. Holder.
That sucks.
Next, we have David Reed.
In making his application, David Reed? David Thomas Reed? Mr. Reed does not appear to be present. Oh, I'm sorry, Mr. Reed. I apologize. His wife went, excuse me, his wife was taken to the hospital this morning. This one needs to be deferred until next month.
Make a motion to defer to the next meeting.
Second.
All those in favor?
Aye.
Motion passes. Next, we have a driver application for low-speed vehicle for Bethany A. Shelton. Ms. Shelton?
Bethany Ann Shelton? I've not heard from Ms. Shelton.
Is this her first time before us?
Yes.
Make a motion to defer to the next meeting.
All those in favor?
Aye.
Motion passes. We also have driver application for an other passenger vehicle for hire by Robert English.
Mr. English? Robert English. Mr. English was the application that I initially left out of your packet that we forwarded to you on Wednesday. This would be his first hearing, so
Move to defer to the next meeting.
Sorry, second.
All those in favor?
Aye.
Motion passes. We also have we've been asked to review a request to modify ownership by adding Ibrahim Yemez to Mesfun Limo Service.
anytime there's a change to the face of an application, the commission has to consider it. Everything is in order.
Said everything is in order. Everything is.
It is in order.
I'll move to approve. I'll second.
All those in favor?
Aye.
Motion passes. We also have a number of new company applications. Do we need to take these up separately or together?
If you'd like to take them in, they've filed all the appropriate paperwork and are in order.
All right, we have new company applications for Alex Limo, Broadway and Backroads LLC, the Leo Rides, Royal Limo LLC, and Zane's Limo Service.
Is everything in order, Mr. Fields?
Mm-hmm.
Move to approve the applications en banc.
Second.
All those in favor?
Aye.
Motion passes. Next, we have a number of disciplinary complaint issues. The first, we have a complaint by James Bradford against a taxi driver, Tariku Yurga.
Mr. Yurga? We have additional action on this and contacting, and this was one that was on last month's agenda. We had a technical problem. I spoke to Mr. Bradford. We thought we had it worked out. Unfortunately, we had I've not heard back from him, so we're not able to have the hearing today because he's not available. I did speak with the company. There's been a great deal of work done on this particular case and issue within the company. Since Mr. Bradford's not available and we've deferred once, I don't know that it's inappropriate to basically throw out the complaint, and then I will deal with. I have a couple of administrative things I'd like to do and work directly with the company and the driver.
I'll make a motion we take no action on the complaint.
Second.
All those in favor?
Aye.
Motion passes. Thank you, Mr. Yurga.
Thank you, sir.
We also have a complaint by Emmett Martin against Joyride and driver Jonathan Lister for overloading. Mr. Fields?
Mr. Martin had contacted me. He'd asked that someone be here to speak for him.
Yes.
Just prior to the meeting, I'd had a call from Joyride. A few minutes before, I had an email from Joyride, I should say, saying that Mr. Lister had not heard from him, and we have not heard back from him. We did send a letter to him certified, but we have not received proof of service back on Mr. Lister.
When you say proof of service, was a letter sent out to him?
Yes, we sent a certified letter to certified mail. Obviously we have proof that it went out. We do not have proof of service. He didn't sign for it. He did not.
Is the commission required to have proof of service?
No. You certainly can take. He was given notice. We mailed the notice. Whether he received it or not, I can't answer that question. with the notice did not come back to us as being received.
Have you looked at the photographs that are attached to our packet, Mr. Fields?
Yes.
Are yours color or clearer than the ones I have?
Mine were black and white as well. The email, did you bring?
I have, so
because-
this one was also deferred from last month at
Correct.
the very end of the meeting. I
Correct.
do have copies on my phone that I can bring up to you guys if you want to see them.
All right.
I was
In
just
color.
curious if we have prima facie evidence of the violation.
He would be able to show you through his cell phone.
Okay,
Do we have Joyride here today?
right.
Is anyone here from Joyride? Oh, there's Chris. I didn't see Chris over
Okay,
there.
great. So we're going to be implementing new procedures starting today regarding complaints. When we hear them before the commission, we're going to give 5 minutes to each side and 5 minutes only. So if you are going first and you would like to reserve a few, like a half a minute or a minute or so to respond to the defendant, or for the lack of a better name, the respondent, perhaps is a better choice of words, please let us know and we'll reserve that time for you. So you have 5 minutes.
Okay.
Go ahead.
So at the end of last month's meeting, when this was brought up originally, Chris Sizemore said that the driver was A.J. Shears. And then when the agenda came out this month, it is now listed as Jonathan Lister. So I'm not really sure where the confusion is on that, if they have such a good schedule with who is on what cart what day. But the reason that we're bringing it up is because if Joyride keeps getting all of these violations, they're going to get all of us in trouble. I work at Sprocket Rocket Party Bike. If they keep getting in trouble, people are going to start looking harder at everybody downtown. So we're just trying to get this out so that we don't get shut down. In the October meeting on the 26th last year, Joyride was issued a 30-day probation after a complaint while they were already serving a 1-year probation. The original probation was 6 months, issued in July of 2017. In August of 2017, it was extended through July of 2018, and yet they just keep getting more and more probations.
Can you
over
cite
time.
us the rule on overloading?
Yeah, hold on 1 second.
$673,360 and $673,200.
Ms. Reed, did you say 6.73?
It's 6.73.360C. And then there's also, under conduct of drivers, there's 6.73203, and that sort of speaks to seat belts. I don't have it right in front of me, but those are the provisions that I picked out.
And 360C, what's the wording of that?
Go
ahead.
You want to do it?
No, I don't have it.
Okay. An LSV used in passenger transportation service shall not drive or transport more passengers than there are proper seating for, excluding the driver of the vehicle, and at no time shall the driver allow any passenger to ride in any area of the vehicle that was not specifically designed as a seat, provided that in no event shall the number of passengers in the LSV exceed 7.
All right, and for this low-speed vehicle, were there sufficient seat belts in place for the passengers?
There were not. And I can bring up a color photo, since that one's not printed well, of the 3 people on the back seat.
Yeah, we'd like to see the color pictures.
All right.
All right, so in this back row where you're facing outward, there are only 2 belts, is that right?
10.
All right, is there anything you'd like to add? I see you got about 2.5 minutes you can save the rest of your time.
Yeah, it's just the one last thing. Also, in that October meeting last year, Chris Sizemore had stated about the geofencing, the GPSs that were already on the golf carts. He also stated that in February of this year that he would have seatbelt alerts and video monitoring on every golf cart, and if that was the case, this wouldn't have happened. So I'm done with that one.
All right. Thank you.
Yep.
Mr. Sizemore?
Sorry about being late up in a funeral, so I got to head back there too. I'd emailed Billy about Jonathan. He no longer works for us and never received a notice about coming to the meeting. But I got in touch with him today. He's out of town working since we let him go, but he would love to come back to Nashville and be at the next meeting. I had emailed Billy to say I had an issue of making it, but I ran down here as soon as I could because he said it was up to y'all to speak with him. I don't know how those notices go out, email or
His particular one was sent out by United States Mail.
Postal Service.
Yeah, with
Okay.
certified.
Okay, so someone signed for it?
That's why I don't have proof that anybody signed for
Okay.
it.
I just spoke with him this morning, sorry. It's been kind of a hectic morning.
Do you have a seatbelt monitoring system?
No, I don't believe that was something that I ever said. The video, we were trying to implement the video monitoring, but, and it's something we could do in the future, but at this particular moment, we can't really afford that. I don't even know of a seatbelt.
Do any of your
Monitor.
carts have belts where there are 3 belts in the back row?
Yes, we do. And so the violation states that it was overloaded.
Did you have an opportunity to see the color photograph from the phone?
I did.
Could you tell if that's a cart that had 2 belts?
It does
3
not.
belts?
It does not.
It only has 2?
Correct. But I think the original complaint wasn't a seatbelt violation. It was overloaded cart, which I didn't
No,
see.
it's both.
Okay.
It says 6 passengers on golf cart and no seatbelts. Would you like to add anything else, Mr. Sizemore?
No, I haven't had a chance to speak with him. We'd let the gentleman go right after that, but he would love to speak in front of the TLC to discuss what happened in the situation.
Do you know if he's working for another low-speed vehicle company?
He is not. He's working out of town right now, but he would like to move back to Nashville. He moved here to begin with, got the job with us, and I guess he's moved back since then, but he would really like to come back to Nashville. So.
Did you let him go because of this complaint, or were there other complaints?
He lost his job here, so he had to leave. Yeah, no, there wasn't any other complaints. It was I think it was his second day on the job. So, and I had a name written down on my list at the last meeting, and I just spoke out of turn of the wrong person that was.
Mr. Sizemore,
on the
you
vehicle.
said he lost his job. Are you talking about another job?
No, he lost the job with us. So.
Why did he lose his job?
The violation.
The
We
violation.
have a zero tolerance for any rule breaking that it's a TLC violation and our rules too.
So
Because
then Joyride doesn't dispute that there was a rule violation.
a rule violation.
Right.
Well, if there's it doesn't matter if there's a complaint or not. We just have a zero tolerance because we're the ones punished for it, not the drivers. So.
I understand.
But his question was, you don't dispute that there was a violation here.
I disputed the overloaded cart, but the seatbelt I can't verify.
Well, you just did a moment ago. You told us that there were only 2 belts on that back row.
Correct.
Okay.
And there's
Yeah.
3 people there in the picture. Okay.
And I wasn't asking you if you agree or that Joyride's violated a rule. I was talking about the driver.
We believed enough to release him.
Okay.
But proof in our instance is if there's any kind of complaint, we usually release the driver anyways.
All right. Well, let's hear back from the claimant one more time. Thank you, Mr. Sizemore.
No problem.
Would you like to add anything?
Yeah, so as he said, he had the wrong name written down the last time, as AJ Shears was the driver. He said that it was his first day on the job, and he got fired immediately. So why would AJ have gotten fired if Jonathan was the driver on his second day? His stories don't quite match up.
Mr. Sizemore, is Mr. Shears, was he also terminated?
He was not. I wrote the wrong name down. I didn't let the driver go. Heather Collier is the GM, and she's responsible for letting those drivers go. And then she saw the mistake and told Billy Fields. It was just my mistake of writing down the wrong one.
All right.
The wrong driver. The right driver was let
Right.
go. So I just misspoke in the meeting.
Thank you, Mr. Sizemore.
Thanks.
Okay, I think we've heard enough. for us to decide what to do here. It looks like it's clear that the driver did violate, at the very least, section 6.73.203 regarding seat belts. Mr. Sizemore has told us that the driver is no longer employed with Joyride, that he that he would like to come back to work for Joyride, but that he has currently been let go. The range of things we can consider, assuming we find a violation, is anywhere from taking no action to probation, to suspension of the driver, to removing the driver's permit to drive. We could also consider, since the complaint was also brought against Joyride, taking action against the company itself.
Although you may fire an employee, do you automatically pull?
In order, if a driver for a company leaves the company for whatever reason, they have to return to the commission for, to advise us that they've made a change, and then we can, you know, unless there's an issue related to the commission, we can reissue the permit. But we do have to change. We do assign, each permit has the name of the company they operate on.
Additionally, you had said that they were on probation. Is there any way we can find out if that's, can we verify that? And if they were already on probation, does that complicate?
Yeah. The company is on probation at the present time.
Can you remind me what the?
Presently now?
I think it's through July. I believe that was the date. I don't have the minutes with me, but I believe it was through July.
I thought it was the 6 months.
Regardless, but this is the second time.
Okay.
Second time on probation.
Yeah, that's what I meant.
I mean, there's.
On probation, but they've been here every.
I think what had happened, there'd been a probation, and then you extended the probation.
Okay.
So violation of the, would this be considered a violation of the probation, an additional complaint?
You could consider it a violation of the probation. The probationary period just means that in lieu of suspension or something like that, we sort of held it in abeyance and for them to be on their best behavior, just like you would think of probation in any other way.
Well, I mean, I will say this. I can't make a motion or vote, but it's pretty clear. We've heard from Mr. Sizemore as soon as he learned of the complaint and saw the prima facie case against the driver, he was terminated. So Joyride, it appears, has taken some strong measures to address the situation.
If we could have order in the room, please. Thank you.
Well, for the simple part, I'll make a motion that we find there was a violation of Rule 6.73.203 in that there was a rider on the back of the vehicle without a seatbelt.
Second that.
All those in favor?
Aye.
Motion passes.
I'll make a motion that we, that Jonathan Lister be banned or his permit be pulled for a minimum of 1 year from being permitted to ever operate a low-speed vehicle in Davidson County.
Second.
All those in favor?
Aye.
Motion passes. Thank you. Next item on our agenda is a complaint by Morgan Pollikiff. We've been asked to postpone that hearing to the following month.
Actually, it may be a little bit later, but I spoke with Dr. Polikoff earlier today. There would have been a technical issue that we would have had, the commission would have had. I spoke with the driver. The driver is going to be leaving the country next week, so we'll have to determine a future hearing, but I've had conversations with both, so we just need to defer.
All right.
Would it be better to put it in abeyance and wait for you to redocket it?
That would be, yes, sir. That'd be fine.
Make a motion to place the complaint by Dr. Polikoff in abeyance pending Mr. Fields placing it back on the agenda.
Second.
All those in favor?
Aye.
Motion passes. Next, we have a complaint by Joel Bundy against Nashville Booting. Mr. Bundy?
Mr. Bundy, Joel Bundy. In the last conversation I had with Nashville Booting, they were in conversation with Mr. Bundy, but I've not heard from Mr. Bundy.
Nashville Booting here?
Nashville Booting, is someone here from Nashville Booting? I would suggest that they probably reached an understanding with Mr. Bundy.
I'll move to dismiss the complaint by Mr. Bundy against Nashville Booting, subject to it being allowed to be refiled if Mr. Fields feels it's appropriate.
Second.
All those in favor?
Aye.
Motion passes. Next, we have a complaint against Jutta Elite Travel and Transport for an unpermitted driver at MNAA.
Good afternoon.
Good afternoon.
Stephen Grauberger here, attorney for Jutta Elite. And I'll have Sean Gaffney with me, who is the owner.
Do we have someone here with the Metro Nashville Airport Authority?
In this particular case, we do not, I don't think they were able to be present. It was from a police officer. We provided you with the email we received on the date listed. There was a incident at the airport, and there'd already been an incident with this particular driver the day before, I believe. And again, that's the reason we brought it to the commission. They were using a driver that was not licensed to operate. Mr. Shaw's application had been denied by the commission previously. With the privilege of the commission, if you don't mind, did the company know he had a permit or not?
It was represented to the company that he had a permit.
Did you ask to see the permit?
That is where my client failed. He, if I could, my client's been in business since 2013 with no complaints. Has currently 4 drivers who are all permitted. Harold Shaw, who's the driver in question, was a subcontractor overflow driver that my client became familiar with as he drove for Regal Limousine previously. Mr. Shaw did. When he came over, he represented, everything was in order. My client admittedly did not do his due diligence. The 2 incidents that were referenced by the airport authority, the first trip was not a pickup for my client. Mr. Shaw had taken a vehicle home. He was an on-call driver, and my client had no idea that he was doing a pickup at the airport. Mr. Shaw was issued a trespass warning at that point. Neither Mr. Shaw nor the airport authority contacted Jutta to advise of the trespass warning. I believe it was the subsequent day. My client had an overflow trip from Grand Avenue, another transportation company, and that's the point that Mr. Shaw was arrested. My client fully accepts responsibility for not doing his due diligence that he should. Mr. Shaw was immediately terminated as a subcontractor. We've had no further dealings with him and will not. But we would ask the commission to consider that my client has been in business for the past 5 years without incident, and he has taken remedial measures to ensure that this doesn't happen again, and would ask that the commission allow my client a little grace in this situation.
Can you tell us a little bit about the remedial measures taken to make sure
Yes,
this
sir.
doesn't happen again?
Well, first off, as it relates to Mr. Shaw, we immediately severed ties, but my client is now, no one will drive for him if he doesn't have their permit in hand. He's got all of his other drivers. We've got copies of all their permits. He's additionally doing background checks on new drivers. In fact, we just spoke about one that lied on his application, and he's not driving. So, you know, he's just making sure on the front end before anybody gets in a car that everything's in order. And he's open to any additional suggestions.
All right. Well, thank you very much. Does the commission have any questions?
We have not had any problem with the company. And again, the process, the one thing, very often I speak with companies, I say, it's really simple. When you're going to hire somebody, you ask to see their application or their permit. In this particular case, it appears to me that Mr. Gaffney understands that that permit should be reviewed, that if he's taking the next step of doing his own background checks, in addition to the ones we're doing, he is also doing them. We've not seen him in front of the commission prior to this meeting.
It just is serious, though. There's a non-permitted driver going to the airport to pick somebody up. So. Just so there's a record on it, I'm going to go ahead and make a motion that there's been a finding of fact or violation of 6.74.100 of allowing a non-permitted driver, and a violation of 6.74.090 regarding the suspension and revocation. Or actually, let me strike that. I'm going to make a motion that there's been a violation of 6.74.100, allowing a unpermitted driver to operate the vehicle.
All those in favor?
Aye.
Motion passes.
My second. Counselor, you said you wanted some grace. What do you think is appropriate, given you know these people and you are familiar with their business practices? What's your suggestion today?
Well, obviously, I would love to see no punishment on my client. However, perhaps I notice in the regulations that a probationary period is allowable.
How long? It's a little tough when your client's right beside you. Mr. Gaffney, how long do you think you should be on probation for to make sure you're compliant, so you remember this?
30 days.
Whoa. Thank you. Thoughts down there?
That seems fair.
I do think I think it seems appropriate to be considering probation. I think it needs to be a little longer than 30 days, but I certainly appreciate counsel's statement about the remedial measures taken by the company to make sure something like this doesn't happen again, where he has a driver who's not permitted operating.
And Billy has them, if there are ever any questions, they can contact your office
Absolutely.
for confirmation. So,
We do keep up with that.
I said, my first thought was more in the 6-month range.
That sounded like a motion.
Oh, sorry. Then I will make a motion that Judah Elite Travel and Transport be on probation for 6 months. Do I need to add anything additional?
Second that.
All those in favor?
Aye.
Motion passes. Thank you.
If I may ask, just for my client's benefit, so assuming he has no further issues in 6 months, this is done and gone?
That's correct.
Okay. Thank you.
Next, we have a complaint by Lori Lancaster against American Melody Carriage for cantering a horse.
Mr. Chairman, Gary Blackburn, we did not realize until we arrived today that you had this 5-minute rule. I'm not here to complain about it. I'm here to cope with it. And what we had done was, because these cases tend to be the same old he said, she said every time we're here, every Thursday of the month we're here, we have employed some highly skilled investigators. They have a short video that I think will give the commission a good idea of what's going on in that location. My clients are here. What they've said in their complaints, they would verify.
It's not the cantering. This is a shoes issue.
Let me speak.
Sorry.
See, I'm hired to do that. See, okay. There are 3. That would be a total of 15 minutes for all 3. My suggestion is that these drivers are here and are prepared to verify the things that were said, which are straightforward. There's a complaint about cantering. There's a complaint about the condition of animals and the lack of shoes. And then there's a complaint having to do with cantering has been mentioned, but also about loading and unloading in a no parking zone.
Can you, Mr. Blackburn, on the agenda, would you identify for me the 3 complaints you're wanting to address together?
Yes. Lori Lancaster, Tina Doherty, not Doherty, and Nama Warren Zuniga. The individuals that we have who we'd like to play the video is presented by Mr. Dan Hodges, who spent 30 years as a special agent with the FBI. He's retired. And Mr. Jones, Rick Jones, who has done extensive investigation, including for the National Football League and presently for the National Hockey League. I have their resumes, which I could submit in lieu of them going through that in the interest of time. They do have this, and I've asked them if they could speed that up and just show the commission the vignettes from it.
All right. I think it's fine to take them up together, so you can have your 15 minutes to do that.
Thank you. Just, you can be seated.
Can we be sure that we know which one he's talking about as we go along? I represent Ms. Robinson.
Yes.
In regard to shoeing.
I understand. Do we have representation here for the other 2 complaints?
The other complaints, I believe, are against.
Well, the only other one I'm sorry. The only other one I see here is the Russell Bassett complaint.
No, I'm not talking about Mr. Bassett. I meant you're only representing American Melody, right? Is there anyone here representing Cumberland Carriage or Southern Comfort?
Just the owners.
Just the owners. Okay.
And Ms. Lancaster, Ms. Doherty, Ms. Zuniga are here if you wish to allow them to be cross-examined. Obviously, you have that right.
All right. Well, I'll let you present your case.
With your permission, Mr. Chairman, this is Mr. Dan Hodges. The one I mentioned to you is a retired special agent of the FBI. He's done a great many other things over the years. He has been involved in this type of investigation since his retirement. Mr. Jones is right here. He's the one I mentioned who was the presently does security for the National Hockey League. Who wants to show this, Mr. Hodges?
I'll be as brief as I can. We were retained by Mr. Blackburn.
I think you might need to speak in front of the microphone. We're on television.
when I was retained by Mr. Blackburn, we were tasked with just doing an objective look at the carriage industry downtown Nashville, because we've read all the complaints that have come before this commission in the past. Like Mr. Blackburn said, there's a lot of he said, she said, and I think at any given time you can point fingers at this and that. We would hope that the carriage industry can survive, and one thing that we're looking at, well, several things, but one thing in particular is the welfare of the animals. Second thing is the safety of the public. And anything that could happen that injures a tourist or a passenger or a driver or anyone else, innocent bystander, can wreak havoc on the industry as a whole. So that's what we're looking at. Mr. Jones is going to run a few very brief still shots and videos and explain exactly what we were doing.
And when you do show us the videos, if you'll identify if this is American Melody Carriage or which company that you're bringing a complaint against.
Yes, sir.
Like Mr. Hodges said, we have several videos, and I'll do my very best to identify which company they are. Just to add to what he said, this investigation was conducted over a approximately 6-week period. We were incognito most of the time. We used a team of investigators. It wasn't just myself. It was about probably 4 others, and we did this various times of the day and various days of the week. And one thing I want to just add real quick is the health and welfare of the animals is something we want everyone to take note of here. You'll see numerous slides where you'll see horses that are obviously malnourished. And I'm afraid at this point that maybe the media may get a hold of this at some point and make it one of their exposés. So every video you look at...
Excuse me interrupting, but we're on a time limit, so if you could start... Not that I disagree with anything you say.
I was rapping.
Yeah.
This is Southern Comfort, and they're going over a steel plate, and that is against one of the ordinance. If the horse were to tip over, of course, you know, the occupants would fall out, maybe fall into oncoming traffic.
All right, Mr. Jones, I want to point out that that is not one of these specific complaints by these drivers, but it is a dangerous situation for animals. But would you please go to the next?
This is cantering. Does that cover it?
Yes.
That's not cantering. Yep. I'm sorry.
And there'll be other examples.
The commission knows what cantering is from about 2 weeks ago. 2 months ago, excuse me.
And which company was that on the cantering just now?
Southern Comfort.
Southern Comfort.
That is plain.
Oh, that's a repeat. That's a repeat.
No, that wasn't. Mr. Blackburn, what were the other ordinances beside the kennel?
Well, it had to do with the lack of shoes. You have one that shows a sore on the hoof. Display that. I was looking for that. This does display other complaint violations. We can submit that at a subsequent time. Loading outside the loading zone was one of them. Lack of rear lighting, these will display that. The driver operating the carriage without holding onto the reins is one of these. As you can see, that shows improper rear lighting or lack of. Which company is that?
That is American Melody. What I'm looking for right now is a slide of a horse that has sores.
There it is.
There it is. I'm gonna go back to the beginning. This is I'm sorry, it may just be a still shot here, gentlemen and ladies, where you can see from this resolution much better, but there's a sore there and there. And I believe this is a shoeless horse. So if you look very closely, you can see where the hoof is frayed. If you were to take, say, some type of I'm a woodworker and I have this tool that roughs up boards. If you were to take the hoof and rough it up, it would be frayed somewhat. It's not pristine. And that is witnessed from this bottom area here where there's a little bit of fraying. And that's because it doesn't have any shoes.
And that was American Melody Carriages again?
Let's ask that. Let's find out who that was.
Do we know who that was with the?
That horse?
That horse there, and my understanding was that was Southern Comfort.
And it is a shoe horse.
And by the way, are you sure there's no shoes on that horse, sir? I'm sorry, this is a terrible way to have to conduct a hearing.
Well, I can only testify to what I saw. And at that time, I didn't see any shoes on it.
You're telling the commission that there are no shoes on that horse?
That's my understanding.
Why is it your understanding?
Because it's what I saw.
Okay, well, you understood from what you saw, so you didn't see any shoes on the horse?
No, sir, I did not.
Oh, okay.
You don't see them now either, do you?
No, sir, I did not.
You can see the place on the side of the hoof of the shoe.
That's something.
Oh, stop, move that back just a second.
Right there?
Yeah.
Okay.
This may be beyond what you have today, but the condition of these animals is horrible.
One of, looks like,
The ribs.
Mr. Blackburn, I mean, we've got a number of complaints before us, and unfortunately, trying to combine them all is making it even more difficult for us to consider the merits of these complaints. So I think we're going to need to take them up one by one. Let's focus on the companies themselves. Let's focus your allegations against American Melody Carriages, and then we can move on to the next one.
Well, I can, if we're going to do it that way, which is fine, then I would suggest we just call the witnesses who made the complaints.
All right.
We're down to 1 minute, 17 seconds.
Well, let's give them another 5 minutes.
Okay.
Cassidy. I refer you to the complaint that you have filed here dated May 5, 2018. This has to do with American Melody. Please just tell the commission what you observed yourself.
The horse did not have any shoes on, and the horse was really bad. Even sometimes you can wear the boots on the hoofs, and without shoes you can only run 4 hours.
You said here that there were deep cracks.
Yes.
How do you know that?
Somewhere there's a picture.
Here, I have a video of it.
Okay. You can see where it's busted.
I have the videos.
Is this?
This is American Melody's horse.
Is this one of the videos we already saw?
No.
Here's the shoeless horse. I have a couple of videos.
And do you have a video where it's clearly American Melody carriages? I think
See,
you
there's
should.
the sign from American Melody. There's her sign. There's her horse. With no shoes. I have still photos as well.
All right. If you'll allow the respondent to see that video as well.
Do not grab things out of my hand. That is extremely rude.
Let him see it.
Now, I want you to tell me when the horse comes in that you're talking about.
American Melody's horse.
Okay.
That horse clearly has no shoes on.
Okay. Where's the cracks?
Hold on, I've got another video.
Y'all will need to, for this hearing, if you can step back in front of the podium as you're discussing it, it will make it where we can actually have a record of this when the time comes, and it
Sure.
might come.
Hold on, I've got two phones because I had to switch over phones. Because I have issues with one.
Still says call.
Would that video be forwarded to
It can be, yes.
Fields, for example, so it can be copied and made part of the record?
Yes, I can do that.
Okay, so other than the video here and the testimony from Ms. Lancaster, is there anything else you want to present regarding the complaint against American Melody
No,
carriages?
Mr. Chairman, there's a cross-examination.
All right. Mr. Allen?
Thank you. When did you make that film, that video?
It was done on May 5th.
May 5th. All right, now.
2018?
Yes.
2018. And how can you show us that it was done on May 5th, 2018? Is it on your phone?
Mm-hmm.
Where does it say that? I want to be sure.
May 5th.
Yeah.
Well, that says May 5th, but
Yeah.
it doesn't say 2018.
Well, this phone is brand new. This phone's 2 days old.
Okay.
So, and I have it on this one as well.
You saw pictures because American Melody got involved in the prior videos that Mr. Jones was talking about. Did you see those from where you sit? Did you see those up on the board from where you sit? I'm talking to you.
Yeah, I can see.
Okay. Do you remember seeing those before?
So, no.
You don't? You were here, in fact, you were part of the presentation at one point against some of the other folks that had the same pictures up there that supposedly...
I'm sorry to say, but those pictures are public record.
Excuse me, let me finish. You had those pictures on the board before, did you not? They weren't taken by Mr. Jones, is what I'm trying to say. This is something that was given to Mr. Jones that this commission has seen before. Quite a few of them. Cantering,
Here's another picture of Melody.
and 2 or 3 other things. So what Mr. Jones has said it's not exactly the way it happened. Mr. Jones was given these pictures, and they're trying to foist it off on the commission as his product, and that's just not the way it was. Now,
Mr. Jones, did you take the photographs and video yourself?
Yes, sir. Myself and 4 other investigators. Now, I will agree that there was some videos given to us, and we used some of these in our presentation, but to say that all of these are given to us and that's what we use, that's just totally a falsehood.
So the videos, are you able to identify which videos were provided to you in part of your presentation versus the ones you actually took and investigated?
If I went back and looked at every single one, I could probably better do that for you, because some of those look similar because it's night. And like, for example, the cannery, for the one that I showed in the very beginning, that I took that personally. And as a matter of fact, I took one from my phone.
and the second cannery picture that you saw was the one we've already treated here in the commission that was found to be not cannery. That was the one going up the hill, coming up the hill.
Right, I remember.
So, now,
All right, go ahead. I'm sorry, I didn't mean to interrupt, Mr. Howard.
interrupting anything, please. Now, this picture you have of the shoeless horse with bad hooves. You're not trying to tell the commission that not having shoes on the horse is against what the commission has ruled on.
It says, according to the ordinance, and I have an email from Billy Fields, and I'm going to read it to you before this complaint was filed. It says, Mr. Fields, I have a quick question about shoes on a horse. Per the ordinance, it states that we have to have either shoes or rubber boots on the horse's mules while they are on the streets working. Is there any exceptions to this ordinance? Billy Fields replied, there have been no changes from what is required by the ordinance. Ordinance 1254-240 B1, be appropriately shod and trimmed, shall utilize rubber-coated pad or boots or open steel barium-tipped shoes or other shoes approved by a veterinarian.
You weren't here on August 25th, 2016, were you?
Nope, but per Billy Fields' email, the director has a final say. There was no ordinance changes, and I have the email from Mr. Fields.
Do you understand that you referred this to, you had a 5-0 vote to amend this back in August 25th of 2016?
It's not changed, I'm aware of. Did the council take that up?
I don't know. That's not mine.
I don't.
Y'all supposed to refer it to the council.
That had to do with rubber shoes, and you decided that the owner could decide the nature of the shoes.
And it had to do with whether they be shod or not.
Even Metro Police Department goes shoeless, and they work in rubber boots.
Not all of them.
Not all of them. Mr. Fields knows that. He's the one that testified before the commission that the police department did not have unshod horses. I mean, this is, they weren't here. And we know what was said, and we know what the vote was. Now, whether it's been referred to the council or not, we know what the commission said. That's it.
All right. Thank you, Mr. Highland. I think we've heard enough to consider the complaint against American Melody Carriages. The complaint is specifically breaking ordinance 1254.240B1 regarding no shoes or boots on the horse. We've seen video evidence of a horse belonging to American Melody Carriages. We've also heard some statements from Lori Lancaster. We've also heard from American Melody Carriages attorney that it's not a violation to not have shoes on a horse. Mr. Fields has indicated to us that there hasn't been an ordinance change and that
We refer to council. Council still has to take it up. But I'm double checking to make sure that there's not been any change, but I'm not aware of it. Mm-hmm.
When is it referred to council?
In fact, we spoke with the council folks about it for action, and again, it's up to the council to take that action.
I guess maybe what I'm asking is there anything in writing that it was referred to council, anything that you folks on the commission are supposed to do? Because you were unanimous. It was what's the problem with what we had as evidence? There was no problem with the horses going without shoes.
The greater issue that I had with with it is I couldn't see the hoof well enough to determine if there was a shoe or not.
Would you like to see the pictures?
I've looked at them. I've looked at a lot of horseshoes over the years. Now again, I'm certainly don't hold myself up as an expert, but
It's our contention that we don't know what horse that is, but there is no evidence.
Well, ask your client, does she have shoes on the horses or not?
No, sir, it was my understanding that since it passed as a motion, which I have the video.
Okay,
and I
so
have-
the answer is no, you do go
Yes,
out there
sir.
without
It was
shoes
my
on your horses at
understanding
times. Okay,
that had been okayed.
I understand.
Can we ask her, do any of your horses have unhealthy hooves because of that?
Absolutely not.
And do you have a farrier look at those shoes regularly?
Yes, he comes every 5 weeks.
And that horse that you saw the picture of, the black horse that you saw the picture of was that your horse?
No, not at all.
Yes, that was your horse.
That was not my horse.
Oh, well, that is your horse there with no shoes.
Whoa, were there shoes on that horse?
I believe there are shoes on that horse because you can see a clip on the side of the hoof.
Yeah. Well, I will say, Mr. Highland, it looks like there has been a violation then of 1254.240 to the extent American Melody Carriages does not have shoes on their horses. And we've seen some video proof, again, from this, excuse me, what is your name?
Kama Warren Zuniga.
Okay, Kama Warren Zuniga. And also a statement from Lori Lancaster. And I understand your position is you believe that the rule had been changed.
Yes.
And that we did pass a motion in August 2016 to recommend a change by Metro Council.
That's right.
That rule has not been changed.
It has not been changed by the council. We understand that now. We've earned the impression that it had been. And I don't know what the status of it is. Does it just die there? Maybe it does.
Mr. Fields, we're sure it has not been addressed by the council.
it has not been addressed by the council. Quite a lot of things actually are recommended, not only by this commission, by commissions and boards all around the city that may or may not be changed by the Metropolitan Council. Typically, what we would do is put together a package and bring to the commission as a group and show changes. We actually are working on drafts right now that would include several changes, not just this ordinance, but other ordinances. And that's typically the way we take things to the council.
So if it is changed by the council, then how do you inform people? Do you send emails? Do you?
We would share email. Anytime a law is changed, what we would just post it on the website and then share it.
For what my 2 cents are worth, there is the spirit of the law and there's also technical enforcement of the law. And it would appear to me from what I've heard so far that Melody Carriages attempted to comply with what she believed was the rule, and certainly within the spirit of the rule. I think you got the message today, though. And I assume you would take care of getting in compliance with the rule immediately, as it's obvious that everybody's looking over everybody's shoulder out there on the streets in the carriage business. I would make a motion we take no action at this time on the complaint against Melody Carriages.
Second.
All those in favor?
Aye.
Motion passes. I guess we should go on to the next complaint, Mr. Blackburn, by Tina Doherty, and also, again, Miss Warren Zuniga.
Ms. Doherty? Sorry.
Start the clock.
Yes.
Ms. Doherty has alleged that Sarah Williams with Cumberland Carriage cantered her paint horse.
Yes.
From 2nd Avenue to 3rd Avenue on Commerce. Would you describe that? What you're alleging here, describe that to the commission.
When she turns from 2nd onto Commerce and takes the left all the way up to the hill to 3rd, she has to run the horse all the way up so that it can make that turn. And she does this with all her horses most of the time.
She runs the horse up 2nd or up Commerce?
Up Commerce, from 2nd to 3rd.
Can you tell the commission your definition of cantering?
Cantering is faster than a trot, less than a gallop.
That's like smaller than tall and larger than small. For those of us who are not horse
I do believe that the last time we had this issue, they had to actually send the video to university for them to explain what the canter was, because they don't have the knowledge.
We're all 4 feet on the pavement.
No.
I believe you'll find that one of the definitions of cantering is that if 3 of the 4 feet are, that they have to be in contact with the pavement for it not to be cantering. Is that your understanding?
Yes.
What did you see?
The horse was cantering up the street. And at times she had to actually slap the horse with the lines to make it go because it did not want to.
And there is a video, just as we had before, on the phone.
All right, if you could show that. Thank you.
I'm wearing a whole new iPhone.
All right, is that the sole complaint against Miss Williams and her company? All right.
Ms. Daughtry.
Yes.
And I may have misspoke.
Doherty.
No, it is against Miss Sarah Williams. Is Miss Williams, would you like to say anything?
I'm Sarah Williams with Cumberland Carriage Tours. I'm the owner and driver of the company. Yes, I did canter my horse from 2nd Avenue to Commerce. I do realize and know for a fact that there is an ordinance to not canter a horse. But sometimes a horse, you have to allow their head in order to let them do what they feel to do naturally. And that means that if you have a load of passengers, which may be 6 to 8 people or less, you don't want to hold them on a hill. And that is an incline. And I don't think that that ordinance was meant for an incline. We have a lot of hills that we have to climb, and these horses have a lot of traffic to go through. And sometimes we have to make decisions in order to be able to get through a traffic light and time that light because you don't know what's coming around the corner. In this instance, I don't think that cantering a horse is a safety violation more than it is for someone to videotape the event and not paying attention to their own details of what they need to be doing. If I have passengers in my carriage or if I'm driving by myself, a lot of times these horses, I don't have to tell my horses to do anything. They're trained to do this type of work downtown in all different types of situations. Sometimes we have to trot our horses up hills. Commerce Hill is an incline. What I usually like to do is sit on a level flat before I ask them to trot or canter. The horse that's in question, which was in that video, that is Platinum. She is a Percheron Morgan horse. Morgans are a natural gaited horse, which means that they can change their gait at any time. And if they trot or canter on a hill, it's not a fast trot. As you can see in that video, the canter is a canter, and I do admit that my horses do canter. These horses have been downtown since 2016. We have not had any complaints by any of the public. I have spoken to Ms. Weiner, which is the vice mayor of the situation here, and I believe that we have been drug into a dispute with Southern Comfort, and I don't think this has anything to do with the safety issue at hand. Ms. Weiner has spoken with Billy Fields on several occasions to pull the files of all these complaints with all these different companies. And she has also spoken with Mr. Fields, and he has also stressed the fact that he is just as frustrated as we all are. Like I said, if Mr. Fields would take the time out of his busy schedule to change this ordinance to make it to where these horses can canter up these hills, we as a carriage industry would appreciate that, because there are a lot of times people want to go to these hotels and they want to go up to see the Capitol building. And everyone here in this room has traveled up Capitol Hill. And you cannot ask a horse to pull a carriage with it's empty or it's with passengers and use all of their muscle to do that. They're not using any muscle at all, and it's not any stress on the harness, which is being used to pull that carriage. So, in other words, if there is no hoof on the pavement, that means that they are in their comfortable zone in order to be able to do what is necessary that they feel is necessary. And I feel it's more of a safety violation to ask a horse to pull an incline when they're using all their muscle, and they could slip just as much as they could if they were to canter. And I think that in a canter and with a horse on a hill or any kind of incline should be allowed to canter.
Mr. Fields,
and these horses are in all control. I have control over all my horses.
Hang on, Ms. Williams. Mr. Fields or Ms. Reed, can you read to us the provision that prohibits cantering?
1254, 200 under, let's see, on number 14 says not that a driver shall not at all times shall not permit the speed at which any horse-drawn carriage is driven to exceed a trot.
Chairman, may I ask a quick question?
Ms. Williams, I didn't mean to cut you off. I had a question for Mr. Fields. Are you through with your presentation?
No.
All right. You can ask her in a moment. Go ahead, Ms. Williams.
I have, what I was trying to stress is that I've been on the phone with the Vice Mayor's office, and she contacted Mr. Fields and pulled all the complaints from Sugar Creek and contacted me back and talked to Mr. Fields, and he said that he is just as frustrated as we are, because it is a trend. It has been a trend for quite some time, and I had asked the Metro Council, which is Freddie O'Connell, Jim Schulman, Erica Gilmore, several council members. I have a great relationship with these people. And, you know, I've been in business since 2004. I have never had a complaint on anything like this. And yes, I have cantered my horses on several occasions because I felt like, as a driver, that you have to do what is necessary to be able to do what you do downtown. And we all know that everything has changed downtown. And that's all I need to say.
All right. Mr. Blackburn?
Thank you. Quickly, Ms. Williams, you and I have known each other for some time.
Yeah.
We've never had a crossword.
Not at all.
Isn't it correct that you do canter your horses on level ground?
Yes. No, not on level ground. No, I don't.
Well, let me tell you something that I witnessed myself. Were you downtown Saturday morning?
No.
You weren't?
No.
Well, there is...
It depends on what day it is because we've had a heat advisory and we have not been able to work since 7 o'clock at night.
11:20 when the downtown was blocked for the festival.
11:20.
I was sitting at the corner of 2nd and Broadway, and you ran your horse through that intersection at least in the king.
Which intersection?
2nd and Broadway. And you went down to 1st Avenue and you made a U-turn at 1st Avenue. Didn't you?
The question is the canter, not the U-turn.
The question is, that's what you did. The point is that you don't limit your cantering to that turn going up a hill. You went
usually,
to the light, to beat the light.
well, as far as the manual on your driver's manual, you have to follow through a light. You cannot sit inside a red light.
I'm asking about you cantering through the intersection and doing a U-turn at 1st Avenue so you can get back to the carriage stand in front of the Hard Rock Cafe. You may justify.
No, I did not canter. If I did, it was probably because I don't know. I don't know if I cantered or not. All I can say is that you're talking about 11. You're talking about November.
No, I'm talking about 11:20 last Saturday with me sitting in traffic waiting on the light.
11:20 a.m. I don't know if we were even downtown last Saturday at 11:20 a.m. I don't think I was, but if we were, like I said, I mean, what I'm saying is that I've already admitted that I've cantered. There's no reason to bring up other events.
I think we've heard enough. Ms. Williams, we've heard enough. Thank you.
Thank you.
Well, we've just heard a presentation on 2 complaints just now regarding Sarah Williams and Cumberland Carriages. Ms. Zuniga showed us some video.
Could I say one more thing, please?
I'm sorry. We're not going to hear anymore.
Okay, thank you.
We've seen some video from 2 incident dates, May 5th and May 6th, of a horse cantering. Ms. Williams has admitted that she does canter her horses uphill, and that is a more natural gait for her horses to do so. Rule 1254.200 provides that a driver shall at all times not allow a horse to go faster than a trot, and I'm paraphrasing the provision. So it appears we have another rule violation. I will say, Ms. Williams, if you believe that the rules need to be changed, I would certainly encourage you to make some proposals so they can be fully considered by the commission and by others. Yeah. We'd probably have a public hearing on whether or not a horse should be allowed to canter uphill. Does the commission have any questions?
What is 1254-270A3?
I'm sorry, what was that?
1254-270A3. 270A3.
(270A3), the animal pulling carriage is moved. It says, "No animal shall be worked under any of the following conditions, and any owner allowed to let the condition exist will be found in violation of this article if the animal is pulling the carriage is moved at a speed faster than a trot." So it's referring back to the first one is a driver conduct, the second is the animal working condition.
And both prohibit having the horse going faster than a trot.
One's telling the driver not to do it, the other one's just making a general statement about the horse.
So 1254-200 is the one regarding the driver?
Correct.
Okay. Well, I make a motion that there's been a violation of 1254.200 subsection 14, where Cumberland Carriages, in particular Sarah Williams, allowed one of her horses to exceed a trot while pulling a carriage.
Second.
All those in favor?
Aye.
Motion passes.
Ms. Williams ever had a complaint here before, Mr. Fields?
She's not been in front of the commission prior to these.
And no one's ever complained about the rate of speed of her horses before?
I'm not in a position to say there's never been a complaint about horse conditions, speed of horses.
Her horses.
There have been no formal complaints filed about her horses until this. There are a number of complaints already filed for next month, and I'm not sure what's in. I've not been able to review all of those complaints, so I don't know what's for next month.
If you'll indulge me for one question or two with Ms. Williams.
Of course.
Ms. Williams, would you come up to the podium a second?
Yes.
I've heard your passionate plea, and,
Yes.
I sincerely believe your interest in the well-being of the horses.
Yes, I would.
Hold on,
Okay,
please.
go ahead.
There is an ordinance that says you cannot go faster than a trot with your horse.
Yes.
So, are you going to comply with the ordinance, or am I going to
Yes.
have to do something about revoking your permit?
No, I will comply. I will comply. Yes, I
Why?
will always do that.
Why will you comply?
Because I don't want to have my company revoked or anything like that. But as far as I just have to make them want to. You know, they can trot, but sometimes they go out of their gait. You know, and it's different breeds of horses that you have downtown.
Whose responsibility is to make sure you comply with the ordinance?
I am.
Okay. Are you going to do that?
Yes, sir.
I'm not going to ask you how, because that's going to get long-winded.
Right.
You're going to do it.
Oh, yes.
How long you been in business?
Since 2004.
14 years?
Yes.
No complaints before this one?
No.
Okay. Thank you.
Thank you.
I'm open to people's input what we do.
The fact that there hasn't been a complaint, and I think you are right, she has the animal's interest at best, but there are clearly rules that say no cantering, and she has admitted to that. I don't know if probation, short-term probation is appropriate. Are there any
There's
guidelines?
not a guideline that would suggest one or the other. I think progression is always appropriate from my perspective, depending on the circumstance.
I'll make a motion that we suspend any penalty for the next 6 months, and if in hopes that Ms. Williams will fall in compliance with the ordinance.
I think that's fair. A second.
What's that mean?
It's hanging over your head.
It's just as what now?
It's hanging over your head. If you, if we see proof of a violation again, then we're able to revoke the permit, put probation, suspend you for a period of time, or whatever. It's basically just sort of like hanging over your head, asking you to be in compliance.
What
Come up to the podium, please.
Like Mr. Fields said, there might be other complaints for next month. So does that mean this time, from this day forward on? Or, I mean, because I could come in here next month with a...
Would it be simpler if we just put you on probation for 6 months?
I just, I have to operate my company. I don't know what you mean by all that, so...
If this passes, it would be 6 months from today.
To not be able to drive?
No.
Sarah, may I?
Go ahead, please.
What it means is they're going to not do anything. They're going to find that there was a violation, which they've done.
Okay.
They would then not take any action on that violation for a period of 6 months.
Okay.
If you don't do anything within the next 6 months, then at the end of 6 months, it stops.
Okay, I'll comply.
Versus if you were on probation, what they would do is they would do another, instead of that action, they would take a different action. They would place your company on probation.
Okay.
If there is a complaint, then you would come back in front of the commission and you would have to address that complaint. If you're on probation, then the next step could be suspension or could be revocation. It could be an extended probation or it could be no action at all.
Okay.
So I think that was his question: is would you prefer probation, or would you on this issue, or would you prefer it to stay out there and be able to be brought back up if there's another violation? And frankly, I can't tell you what's in the other complaint.
I'll just take whatever you said.
All right.
So
I
promise I won't.
Put it on, to suspend it for 6 months.
I'll second.
All those in favor?
Aye.
Motion passes.
Thank you.
Now, and we did make a finding that there was a violation of the rule for both complaints, right? There's one dated there's two complaints dated May 7th, but one's for a May 5th violation, and one is for a May 6th violation.
Just to be real clear, I'll amend my previous motion to include both May 6th and May 7th of 2018 for 2 violations.
I'll second.
All those in favor?
Aye.
Aye.
Motion passes. Next, we have a complaint against Southern Comfort for employee misconduct that's being brought by Zanita Ramirez, Warren Zuniga, Daniel Balazzi, and Glennis Wheat.
I haven't been directly involved in this one, so I'm going to let them think that.
We're on the clock, right? Yes.
As for Glennis Wheat, he is unable to be here. He is back in Louisiana.
Please step up to the podium. Thank
For
you.
Glennis Wheat, I do know that he is unable to be here anymore. He is terminally sick with multiple sclerosis and has to be down with his doctors down in Louisiana, so he is unable to be here for this.
All right. Thank you.
So we're going to show you some video, a little bit of video. I hope it's kind of clear. Southern Comfort had a ranch hand. Unfortunately, we don't know his name because we do not converse for the most part per our company policy and per the request of the TLC. Harassing our drivers, selling carriage rides for their carriages in front of our carriages. And when he was asked to leave the area of our business, a confrontation did arise. numerous times we'd seen this ranch hand of theirs perform in an unprofessional manner. He would have his girlfriend or wife, I'm not sure who she was, would be down there sitting, and somebody would come and talk to her, and he would confront them as well. He'd also confront our passengers as they got off of our carriages and harass them about why they rode with us and everything else on numerous occasions.
Is there a particular employee you're complaining against?
It was their ranch hand. Unfortunately, we don't know his name because we don't converse with them. It's pretty much their general practice with their ranch hands to have their management in their carriages control their employees.
Is this the complaint that was filed by Zanita Ramirez?
This is Anita right here. Right here.
So is that the video proof?
That was the video, some of the video proof, yes. Unfortunately, we had a camera that had it on, and I believe it was damaged due to water from the rain.
So
think
were
that's-
you
yeah.
there personally?
I was there, yes.
When this happened?
Yes.
So I'm confused why you're not making the complaint instead of Ms. Ramirez.
Because I was sorry.
She was our ranch hand.
I was ranch handing that night, and I was the one that got stuck in the middle of it. So I had to make sure nobody was gonna get into a fight, because they were about to get into a fight. But it was the other ranch hand was just starting it, and he was starting to go towards us. So I stood in the middle of it to stop it. And then the ranch hand ended up calling the police.
So this is a separate complaint.
So Ms. Zuniga and Ms. Ramirez, you all are bringing the same complaint for the same
complaint.
incident?
Same
Okay.
incident, yes.
So we have a police report?
Yes, I provided a copy of the incident. There's no police report that was, I guess, taken.
It would be the field information ticket that would be a part of that particular document right there.
All right, is there anything else you'd like to present?
No, thank you.
All right. We'll hear now from Southern Comfort.
The person they're referring to is Jonathan Warren. He doesn't really work for us anymore. He worked a few days, but it's so strange to me. He goes out, that's the first time we've ever had a male that did the soliciting. He goes out, he does exactly what they have done with 3 people for more than 10 years, and they're going to write a complaint about it? This is unbelievable. But that's what we deal with every single night. He's gone. The reason he's gone, not because he did anything wrong, but because he was harassed so much by them. And when he came to me to explain it to me, I told him once again, like I tell my drivers, we can't do anything about their harassment. So he, like several drivers have done, if you can't keep them off of us, then we're gone. And so he's gone too.
I'd like to say solicitation was only allowed starting in 2013. The laws were changed in the ordinance.
On the video, who was cursing? I couldn't tell.
That was their ranch hand.
It was also your ranch hand.
Anita was our ranch hand that night. Anita was our ranch hand. She was eating an apple.
There was you know who else was there that night?
That was kind of gay.
In fact, I pulled his name out right here. Because if he wasn't there, how did he file this complaint to match up to y'all's story? His name was Glennis Wheat.
Yeah, he was the husband of
He was the husband of one of our drivers.
He was down there overseeing her.
He was also working because he's the one that got in the confrontation with Jonathan.
Do we have ordinances based on ranch hands?
Ranch hands are not licensed by the commission.
Is there a general code of conduct?
There is not a specific part in the ordinance that talks directly to the conduct beyond driver conduct and the fact that each company is responsible for the actions of anyone that's representing them on the street.
Mr. Morrison, right?
Yes, sir.
Now, Jonathan Warren, who was down there, you described him as a ranch hand?
He would solicit the rides and water the horses.
Is that what a ranch hand does?
Correct.
Takes care of the horses and deals with potential customers?
Yes.
He was not a driver or anything?
No.
All right.
And the complaint is specifically.
If I could offer a solution, if y'all would consider it. Several years ago, more than 10 years ago, they started the soliciting. When they did, they would hold rides. I would pull up empty. I would tell the people, you don't have to wait. You can ride with us. Some of them would get on. So when they got on, they would say, you won't believe what they're saying. I said, well, tell me. Well, they're saying you don't have insurance. They're saying you're an alcoholic. They're saying that you've got a dangerous horse. And on it goes. So when Brian was here in Billy's position, we complained so much that y'all stopped it. No solicitors, no problem. No one taking videos, no one making false reports. But the good lawyer here was able to get them back because he claimed freedom of speech. The drivers have freedom of speech, let them talk. We don't need more troublemakers on the sidewalk making false reports, harassing other companies. And y'all had it stopped, and now it's back, and it hasn't stopped.
What happened with the police report that Southern Comfort filed?
I thought we made the report.
We did make the report.
We're the one that made the report.
All right. What happened with it?
Nothing, it's just,
It's just a number.
you know, the citizen number.
There was no action taken. We spoke with the police officer.
Yeah, we just called because he was harassed so much, he called them.
So you called the police?
We spoke with them.
We called
Yeah,
them,
but-
and then they spoke with them,
All right,
correct?
that's all I want to know is whether any action occurred.
No, sir.
All right. And you're saying it's coming up next month somewhere?
I heard it. Yeah, I didn't file a complaint, I just know that I leaked that information.
Okay.
All right, is there anything else regarding the complaint against Southern Comfort? All right. Thank you. That's all we have for now. Do we have any questions by the commissioners?
Has a rule or ordinance or anything been violated by just an argument?
If you determined that this was detrimental, this was potentially detrimental to public safety, you could determine there was a violation.
What if we determine that it's just offensive and detrimental to the tourism industry as a whole?
You would actually have to create a rule or ask for a change. But you certainly could generate a rule, not today, but you could generate a rule that would address treatment, the manner in which companies operate and their representatives.
What if we were to find that because of the history of complaints and everything going on, that it's just time that we recommend that the carriage industry be terminated in Nashville because it is a detriment to tourism and the public safety?
Again, it would be action that would be...
Can we do that at this point?
The commission has authority to... You don't have the authority to terminate. You have the authority to recommend to the Metro Council.
To change the
Correct.
ordinance up there, okay. Because I think we're reaching that point. Or if not reaching, we've reached it.
What about changing the rule where we stop soliciting, as recommended by Southern Comfort?
The issue came up in actually I think at the end of 2012. We asked Metro Legal to review it and determine that there could be questions on the constitutionality of stopping someone from soliciting.
Well, the problem that it looks like we're having is we're receiving a number of complaints regarding employee misconduct, and it centers around, the passenger pickup and drop off, as opposed to, the cantering horses or not having the shoes or whatnot.
There are probably several remedies that you could consider. One would include, and we've talked about this, actually placing. We'd have to seek funding, but we would actually place an employee of the metropolitan government on location in front of that. Obviously, the money would have to be recovered from the industry themselves, and we would create a starting position, very much like they would have in Charleston is the most prominent example, where all rides go through one location, in and out, one location with government employees starting, and that's where they start and stop.
And payment goes.
And I'm sure, and there are probably others as well.
How would, obviously the Metro does not have budget resources to have another employee, but how would we pass that cost on to the carriage companies?
We would ask if the ordinance, and I think in this ordinance, the commission actually has authority to deal with fees by rule. The annual fee for carriages is established by rule of the commission. Rule number 3 under horse carriages, you set the annual carriage company fees. You set the driver fees, the carriage fee, and the annual company fees. Under Tennessee state law, we're only allowed to collect enough money to cover, for anything we do, to cover the operations of the department. If there's an operation, then under state law, you have the authority to create a fee that would meet that. We'd ask Metro Legal and Metro Finance to determine what that would be. They would also probably work with the state comptroller. I don't know that particular part, but that would be my guess.
So we could start looking at possibly employing people who could start monitoring these folks who can't get along.
Yeah, beyond what the inspectors do, we've, as you know, in the last 5 years, we have more than quadrupled, I suspect. I could get you exact numbers, the amount of vehicles, drivers, and so forth that the commission's responsible for. Within the next month, I will be sharing with you more that is coming, additional kinds of transportation, and then probably in months ahead I'll be bringing you additional information from the council regarding transportainment, which are the other vehicles that are operating in downtown Nashville. So there is more work, unfortunately, coming.
If we went back to the rule how it was prior to 2013, where the carriage companies could not solicit passengers. Wouldn't that address some of the issues we're dealing with?
It certainly could. I can't specifically address whether that, I mean, obviously, I don't know that it would end it. We had the rule in place from 2002 to 2013. Or in that vicinity, I suspect.
I suspect we're just going to change complainants. Or you know, I'm ready to start designating where they're going to be, where they can pick up and drop off, and hire carriage police to start monitoring these folks. So, you know, with their own video equipment, and pass the cost on to the carriage companies. Maybe we'll, you know, because it's taking up a lot of time of this commission every month. You know, but
It's exactly right.
Is it
It's
possible
really
to get a
a waste
study?
of y'all's time.
I mean, I don't want to spend a lot of money, but, or just even the framework of how Charleston handles it. Isn't that the city you referenced?
Well, there are several cities we may need to look at. But we could certainly either determine that we gather information or figure a way to find someone that could bring back information to the commission in the form of a study on starting and on the carriage specifically. And it's possible the KCI that has done the traffic study, which I hope will be back for you to look at in July.
Yeah. I feel like there needs to be some type of roles and person in charge that handles
monitoring.
Yeah. It's a good word.
Okay, well, does someone want to make a motion regarding the complaint against Southern Comfort? I should say complaints brought by Zanita Ramirez and Kama Warren Zuniga. It looks like we should dismiss and take with no action the complaint by Glennis Wheat, since he was not able to appear today. Is Mr. Balazzi here? No.
All right, I move to dismiss the complaints by Daniel Balazzi and Glennis Wheat.
I'll second.
All those in favor?
Aye.
Motion passes.
So then we have the other two? Or is that
There would,
two more?
again, your range of action is determine there was a violation, determine there was not a violation.
And the
If there was a
violation would be-
violation, then you would proceed with if there's any penalty.
Public safety, right.
You'd have to determine that it was a violation, that it would be a public safety issue.
It's a public embarrassment, but.
Yeah. That's what I'm thinking. I don't, based on the video, I'm not sure that you could see anything that was a public safety issue. But I think it's certainly not helpful to the tourism part of the city. So I don't, if there was not a violation, I guess that's what we're voting on.
It is under drivers.
Yes.
Do we have to dismiss, do we have to dismiss the complaints?
If we can't find a violation that they've,
Just dismiss it?
a rule that they violated, then yes, we would need to dismiss the complaints.
We'd need a motion.
One of the things
But we
that-
need to have a motion first.
One of the things that has happened, we've instituted, you actually made the request a meeting or two back. Any complaint comes forward has to have from this meeting forward, has to have a specific notation of what is in violation that's within your authority to deal with. It can't be other ordinances. It can only be 672, 673, 674, 675, 1254, and the booting number that just now has escaped me.
I can't, I don't see any, from the video, I can't tell that there was any violation of public safety. So I can motion to dismiss the complaints, both by,
Ms. Ramirez and
Ms.
Ms.
Ramirez and
Zuniga?
Yes, sir.
I'll second that.
All those in favor?
Aye.
Motion passes. We also have a complaint by Mr. Bassett against Sugar Creek Carriages and Johnny Smith for a probation violation.
I promise you I'll keep under my 5 minutes. You know as well as I do the agreements you made in November with Mr. Smith and his attorney about him being barred for a year, and Mr. Blackburn said that he wasn't necessary for carriage operations, and several weeks later, he's driving down Broadway. Granted, it's the Christmas parade, but he's driving down Broadway immediately after he agreed not to be downtown. So it's up to you to find whether or not that was a violation of their agreement.
Mr. Chairman, I'm not sure whether Mr. Bassett was here in November. Perhaps he was, but I have provided to you certain pages from the transcript, the record of that meeting. And as you know, there are two votes that are always taken. One vote is to find whether there's a violation. If that vote is no, that's the only vote. And if there is a finding of a violation, there's a second vote that has to do with whatever punishment or penalty is assessed. Those are the subject of separate motions, are the subject of separate votes, and are separate entrances in the minutes. We asked in November that the Sugar Creek penalty only be altered to provide that he would be on probation for a period of time, and he offered to avoid being present, and this had to do, however it was expressed, the sense of what we're all talking about was it had to do with the sort of incidents that you've been looking at this afternoon on these videos, the downtown nightly carriage trade. Now, the problem with this complaint is that you found particularly that on page 37, Ms. Costonis from Metro Legal said, because the provision in the rules that says that their disciplinary action is suspended while an appeal of the previous decision of this commission is pending, Mr. McNally, so they've never lost the ability to operate. Ms. Costonis, no, not to this point. And then, Mr. Chairman, you made it clear that the finding that had already been the subject of the appeal and upon which the certiorari had already been granted was not the subject of the hearing in November. Consequently, by virtue of the action that you took and by virtue of the advice that you received from Metro Legal at that time, it was plain that the penalty part, whatever it might have been, was not in place yet because of the appeal. That is proceeding. In fact, one party's brief is due tomorrow in that, so that is proceeding. But as we speak, that is stayed as a matter of law, and there's been no attempt to seek relief from that from the Chancery Court, nor any need to do. If I could quote you, Mr. Chairman, from page 38, well, I think that it's two separate issues because regardless of what we do, whether Sugar Creek and if at Mr. Blackburn's advice decides to pursue its appeal or not, that's their decision. You know, they've come to us today asking to revise our decision with regard to the punishment imposed. And regardless of what we do, they may pursue the appeal on the merits of the issue, whether there was a violation. They can do that. Their motion, from what I understand, the motion before us today is that they want to know that. They're asking the commission, please reconsider the punishment so that for them, the worst case scenario is if their appeal fails, then they're only going to be dealing with a probationary period, et cetera. Now, that was what was determined. That's what everybody understood that day, including Mr. Smith. Although this may not have been precisely articulated, what we proposed was that he not be present in the downtown carriage operations for a certain period of time so as not to, so that there would be fewer of these disputes. I don't think that worked. but nonetheless, he has adhered to that. This had to do with a particular special event, a Christmas parade, which he was asked to attend and in which there were no issues. He didn't understand that to have been a violation of even what he proposed. However, it was not in effect at that time.
All right, I'm not real sure about this, but this is part of the code, and did they provide documentation required for operation during a special event?
Chairman, this is irrelevant.
I'm not done yet presenting my summary.
This is irrelevant to anything that's before the board.
Is he entitled to continually interrupt my summary?
Mr. Bassett.
I'm trying to use my 4 minutes and be done.
I understand, but this isn't really part of your complaint.
No, but I don't think walking on steel plates was part of their complaint. But let's move on. What is probation? It's a second chance, an opportunity to show you can behave, a chance to stay off the radar. And one of the things Mr. Blackburn said at the November meeting was this would be a terrible temptation to file frivolous complaints. I thought it was a dire warning that we were going to do it. They apparently heard it as a call to arms, a war cry. They have filed 17 complaints in the last 3 months. I filed this complaint, and I filed one in November. Prior to that, I had not been in here since 2012. But I'd like to move on. And one of the things Mr. Blackburn said in the meeting repeatedly was that in an effort to save time, and they presented a lot of declarations, sworn testimony, and it was under oath. And I'm just curious as to a part here where, and if you want to acknowledge that this is a copy of the declaration that you submitted.
Completely immaterial and wasted.
Is he allowed to keep interrupting my summary? I'm just going to say, I gave him the opportunity to acknowledge it.
Mr. Bassett, I have a question for you. Do you have a response to the fact that they had their appeal is pending, and so the punishment and that we found to be appropriate was stayed pending the appeal?
Commissioner McNally, with a second from Commissioner Marco, moved to place Sugar Creek Carriages on a 1-year probationary period. Owner Johnny Smith be barred from downtown carriage operations for 1 year, and that Sugar Creek Carriages be held accountable for the actions of all drivers and employees. So it seemed to me they negotiated a plea agreement, and Mr. Smith no longer cares to follow it through. But as I was saying in this declaration, sworn under oath, Mr. Smith stated, I purchased the carriage stand to be a resource to all horse carriages, not only for Sugar Creek. Now, I checked with traffic and parking. It's impossible to purchase a carriage stand. But he did it out of altruism. He did it to help take care of the horses and build camaraderie among the companies. So, and I would like to point out that every time that he said, she said, again, on every he said, she said, Sugar Creek is on one side, and as of today, all 3 remaining companies are on the other side. So, I find it interesting that they didn't call animal control on those pictures they were showing. And I believe that's because they called animal control so many times, animal control told them to stop calling. They called the police so many times, the police don't want to be bothered. So basically, did he violate it or not? That's your call, your decision. I didn't come in and make the agreement to be barred. And I thank you for your time.
Mr. Blackburn, is Sugar Creek still pursuing its appeal
Yes. Yes, we are.
What's the status?
The status is that the chancellor put down a schedule, sort of a case management order. Tomorrow is the deadline for Sugar Creek's brief, and then there'll be time for that, and then it's going to be scheduled. I don't recall the date, but then it'll be scheduled for an oral argument primarily. It's technically possible to submit additional evidence. That's a little confusing the way that statute's written, but that's the status of it.
Chair, Metro Legal has made a motion to dismiss the writ for mootness because what he originally appealed, if you look at the punishment was originally appealed, so the question would be what relief are they seeking if they actually got the relief that they wanted, which they did. That's the purpose of coming before you. So there is a motion to dismiss pending, which I believe they're going to be arguing over. And our argument is that their initial writ is now moot.
So it is still pending, active litigation pending right now?
It is, and our
Okay.
position is that it's two separate.
Right.
Yeah.
There's motions
Correct.
for various
Right.
jockeying
Absolutely.
positions and everything up
Right.
there. All right, now, is there any change in what Ms. Costanza said back in, I forget what date it was, but where she was of the opinion that while there was an appeal pending, the punishment was not in effect?
Well, that premise stands. I guess the argument would be, and the argument that legal is making is that it's two separate punishments imposed. So we're talking about two separate incidents. So what they're appealing is the first incident, the first punishment imposed. And so since you changed that and you gave them a second bite and you changed what that punishment was, what relief do they want? They got the relief that they needed.
But from what I can, but Ms. Costanza had said that as they were appealing, the punishment that we imposed, whichever one it was,
Right.
was kind of in abeyance pending the appeal.
Yes.
And that's still Metro Legal's position for today on this matter, or for
Well,
today.
we see it as two separate.
Or is their appeal for, are they appealing the punishment, or are they appealing the merits of the decision they were found in violation of the rules?
I just proofread the brief. I can assure you we're appealing the finding because we had that discussion, Mr. Chairman, at that time. The question was, well, if we grant this, does that moot the appeal? Will you still go ahead? That was the point of the discussion you and I had about whether I would suggest to Mr. Smith that he not continue with the appeal. When this issue was raised, it was in the absence of the November transcript. The November transcript finally was produced. That was the delay, that was what caused the delay in the briefing to just start with our brief tomorrow. In that brief, we now are able to quote at length from what happened in November, which makes it clear, absolutely clear, that what we're seeking is to set aside the ruling of a finding of guilt, so to speak, or violation. And that's what our brief concerns. There's no serious question about that.
Because I'm looking at page 37, and it's pretty clear Ms. Costanza is saying because of the provisions in the rule that says that their disciplinary action is suspended while an appeal of the previous decision, this commission is pending.
There is a letter. Part of that process is that it is stayed by operation of law unless Mr. Fields, in this instance, the executive director, finds that the violator would be an immediate threat to public safety. He responded to that and said that Sugar Creek was not an immediate threat to public safety, therefore the stay went into effect. And that's not been altered.
Which judge do you have assigned to you? Do you remember?
We have Fourth Circuit, Division 4, Perkins, Russell Perkins, Chancellor Perkins.
All right, thank you. Well, it seems to me that the finding of the violation and the punishment we imposed for that violation is stayed pending the appeal.
Well, I'm on a roll. I'll make a motion to dismiss the complaint by Russell Bassett against Sugar Creek for the reasons that were just stated by the chairman.
All those in favor?
Aye.
Motion passes.
That was a big wash.
Next we have we've been asked to review a TLC staff report on Music City Touring and Ken Ross. This was deferred from the May agenda.
Mr. Ross? Kenneth Ross? He's in the back.
He's coming.
Good afternoon. Ken Reddit on behalf of Mr. Ross. He has retained me to assist him in addressing these matters here today before the commission.
Good afternoon.
Thank you.
Mr. Fields, would you like to make a preamble statement?
At your meeting in March, the commission determined that the company had violated 6.73.060F, failing to have insurance. The commission levied a fine of $2,425 that had to be paid in 30 days. The company was placed on probation for 180 days. The 30-day payment was due on April the 20th. He did not make the payment until May the 1st. I brought it to the commission meeting to advise you that he had not paid it on the time. As you had suggested, he was not present at the meeting. There was the issue of whether he knew or did not know. And as I said at that point, rather than take any action, I'd ask you in an abundance of a desire to make sure we were fair to defer that until a date that he could be here so you could discuss why he was unable to pay the fine within the time period that you had suggested or that you had ordered.
Right. You may proceed.
Yes, and if it pleases the commission, what I would like to do is ask Mr. Ross some questions. I think that would kind of crystallize what happened in his position. All right.
And I'd like to say first of all is that I don't want to have it as us against them, you guys against me. Could communication have been better? Yes. Did the fine get paid? Yes. Did we have the ability to pay the fine? Yes. But if Mr. Reddit wants to expand on that.
Yeah. Mr. Ross, did you call the licensing commission to find out about making the payment?
I did, yeah.
Okay. And when did you call the licensing commission?
On the Friday the 20th, I believe it was. 20th of March. Or 20th of, pardon me, 20th of April. Sorry.
20th of April?
Yeah.
Okay. All right. And did you speak with anyone?
I did. I spoke to a female at reception, and I asked for Mr. Fields, and at which time he was not there. And I left a message to that effect that I wanted to speak to him. My intent was to find out where I could pay the fine and how to pay it and who to make the payment to. I did have, go ahead, I did have ability at that point in time to pay the fine.
And so you called on Friday, April 20th, how many times?
3 times.
3 times, okay. And you were prepared to pay that day? Is that your testimony?
Correct.
Okay. And it was a little late in the evening that time, so were you prepared to pay that day by credit card?
It was in the daytime. You said evening, it wasn't evening.
Well, what time was it when you called?
Just after 3 o'clock.
After 3 o'clock?
Yeah.
Okay, well, I don't know what time they closed, but it could have been a little late.
I was prepared to either pay it by credit card over the phone or drive over there and drop off a check.
Okay. And did you follow up with an email?
I did.
Okay. And when did you send an email?
On Monday, the 23rd.
Okay. And what was the content or purpose of the email that you sent?
Got a copy of it here. So basically, I just wanted to know when and where to pay the payment amount, where to pay, who to endorse payment to, acceptable forms of payment. Thank you for your assistance in the matter.
Okay.
It's on the bottom. That's the summary.
May I approach?
Oh, hang on one second. You want a different one on that one?
Oh, yeah.
That one? Yeah, that's one. Correct.
Are these all copies?
Yeah.
And what about the phone record?
Yeah, we got those.
Mr. Ross, I have a question as well.
Yeah.
So I understand you tried to make a phone call on the 20th.
Correct.
About making payment, and then you followed up with an email on the 23rd, the following Monday.
Yes.
Did you get a hold of anyone on Monday, or did anyone respond to your email?
Mr. Fields emailed me back and said that he was in a training session and that he would email me the details the next day.
Okay. And did you receive any follow-up from Mr. Fields?
I did not.
But you ultimately paid on May 1st?
I did ultimately pay.
So what transpired between Monday the 23rd and May 1st? Why did you wait till the 1st to make the payment?
To me, I was waiting for Mr. Fields to get back to me, and I tried the office a couple times, and he was actually out of the office, I believe, on holidays at that time. And then we also had renewal of our licenses going on, and I had a driver going in there. So we had some interaction upcoming with the office, so I wanted to at least make sure that someone would be there to address the matter when I came back the next time.
So you were going to be in the office on May 1st, or the TLC office?
Well, I
May
was in
1st?
there on the 30th. After we tried to get a hold of somebody during that time, I was in there on the 30th to do our renewal of our licenses and pay, at which time I offered to pay by check for the fine that was due, and I was told they wouldn't take a personal check, so I offered to come back the next day with guaranteed funds in form of a bank draft, which I did.
And also, the 30th day actually fell on the weekend of the calendar, and so the 20th would have been the 29th day that Mr. Ross did attempt to call those 3 times, and you know, and if it pleases the commission, I have Mr. Ross's call details from that day to substantiate and support the fact that he did in fact call, and also his email that sent correspondence between him and Mr. Fields, where he specifically asked about where to pay, and I know that was afterwards, but that was the first business day after the 30 days. So if the commission would be interested, I have that information.
I'm looking at my calendar. The 20th, April 20th was a Friday.
Yes.
And then April 30th was a Monday. And the May 1st was a Tuesday. So, Mr. Ross, you came into the office on the 30th of April
I did, yeah.
and tried to pay by personal check?
Yes.
All right. Well, Mr. Ross, do you understand why you were asked to come before the commission today?
I mostly understand. If you can explain to me.
Well, I think the main thing is just the delinquents in paying the fine. And this is, I mean, it was a very serious violation that we found, not having insurance in place. And, I certainly understand and appreciate that you did pay the fine. No one's disputing that, but you were late, and
I wanted to clarify that we.
Hold on, let me finish.
and the issue we have is there really isn't an excuse for being late. If you weren't sure the process in making payment, you should have reached out well before April 20th. But you didn't, and that caused you to be late when you didn't get instruction as to how to make payment. But regardless, I mean, you could have been in the office that following Monday, you know, with funds in hand to make the payment, and that didn't happen. So that's the issue. That's why we asked you to come before us today. If this had been a metro ticket or a police fine or anything like that, there would be more serious consequences than not paying, you know, the Transportation Licensing Commission that you could potentially be dealing with. But nevertheless, I mean, you had a deadline of April 20th to make a payment of the fine, and you didn't.
Mr. Fields, I've been on this commission a number of years. I don't think we've ever had a situation like this before. Do you, in your memory, have any experience with this?
Typically, if the commission makes places in order, the orders follow.
And chairperson's correct. If you didn't pay your fine associated with driving on a suspended license or some other traffic ticket, they take your driver's license until you did get in compliance. So should we take your permit or something?
Well, I would.
For the number of days that you were delinquent?
I would ask that that not be on the table, in the fact that we do have myself and others that depend on the livelihood for this. And
Counsel, you've put forth a good case with a difficult situation. What's your suggestion for a consequence as a result of this?
Yes, sir. I appreciate the question, and appreciate the time spent in ensuring that Mr. Ross understands, you know, specifically, you know, what it is and what.
Because I'm inclined to think a suspension for the number of days that he was late getting it in is appropriate.
Well,
so tell me why I shouldn't.
What I would say is that you know, thankfully he did he did pay it, and the effort, and I would agree that there could have been sooner than waiting till the 11th hour to try and find out, even though at the 11th hour he would have been, by virtue of the days.
Well, let's get past the 11th hour. Let's get to the next day, or the next business day.
Monday, yes, sir.
With cash in hand down there to make sure it's in compliance.
Yes, and that was part of his, and I guess that's why the two kind of go hand in hand, because with him not being, you know, has testified to not being certain as far as method and means of payment, then I guess the two goes hand in hand. But Mr. Ross makes no excuse. He's clearly 9 days. Was 9 days late in payment. That is uncontroverted, and would just ask that, you know, since ultimately he did make it right. He has taken these proceedings serious, you know, and obtaining counsel and making sure that he is in compliance. Now, I would just ask that if a penalty is imposed, it's something to be commensurate with the commensurate with the infraction of maybe something by way of a small fine, by way of a small fine for, you know, commensurate with the infraction. You know, he was late 9 days, and as opposed to a suspension that would affect the livelihood, he has, you know, already, you know, he has been fined and has had to pay that. So that would be my thoughts. I think would be something that would. But I think Mr. Ross understands what he's done, and he can't.
Be interesting if we imposed another fine to see if he showed up on time with it.
I feel very confident that he would. Absolutely. When I don't think he would wait till the day or two before he gets in contact with Director Fields or someone from the commission to make sure and ensure that he comes in and he pays timely.
I suspect you're right.
What's the daily fine? I remember this.
You can fine up to $50 per day. However, you chose to only do half, $25 per
Right, I
day,
remember.
and that's the way it was determined. If you were to fine him now, you could certainly do $50 per day.
And it was over insurance, is
Mhm.
that right?
Failure to have
Correctly.
insurance. Could I ask one question? Because this really has been a problem for me. Mr. Ross, do you ever get emails from me?
I do get emails from you.
But they're sporadic. Some you get and some you don't. Is that correct?
Yeah, and I honestly, I know it doesn't look forthright, but I honestly did not get the email that was sent back that you claimed, that you said on the 24th. And I apologize if there's any miscommunication. I will promise to be better and provide multiple emails, multiple addresses if you need, and have other contact points for my company. I sincerely apologize. I don't want to get into the thing of he said, she said, and I do respect the commission and what they stand for, and I was making honest attempts to pay the fine, and I feel badly that it didn't get paid in the time that we had intended it to. We did have the funds. We did make attempts before the end of the period had lapsed. And to me, I wasn't sure at that time whether it was a city item or TLC, where, I just wanted to clarify whether I could pay it here, over there. But I apologize for any miscommunication on my side. But it is our livelihood, and I would ask that the licenses.
How many people you have employed?
4.
4, including yourself?
Yeah.
Well, I do think it's important that we find a violation and try to come up with a penalty commensurate with being 7 business days late. And I don't think it requires suspension, but I think it's important that we are consistent with how we handle late payments of fines. So I think it would be appropriate, as this council has suggested, in coming up with some kind of late fee against Music City Touring. And, I think if it's, I don't know, $20 a day or something like that.
That was $150 a day since we were generous with the original fine. That would be $350.
We in agreement that there's 7 business days that it's delinquent?
I just felt like we were
$350.
$350. Thank you for confirming.
Is that a motion?
I would say yes. I make the motion that he was in violation of getting his payment in on time, and because of that, we fine him an additional $350 that will be due. What is today?
Today's the
28th. So,
Mr. Ross, when
Monday.
could you pay $350?
I can pay it tomorrow if you want, but if you would want to give me 7 days or 15 days, that's fine too.
You're not getting some rope to hang yourself here now, with
No.
I would say by end of day Monday, July 2nd, is your office open?
Yes.
That way you get it done and get it over with.
And now
you
we
can
know
enjoy
the-
your July 4th.
And you know how to pay now. We know the process.
Actually, who does the payment? Who's it endorsed to? Is it transportation
It is-
licensing, or is it city?
All payment goes to the metropolitan government.
So it's
It's
called.
turned into it goes to the treasurer. None of the money resides with the Transportation License Commission or Public Works.
And it should be, I would pay it by a cashier's check or money order, something that.
So do you want me to send it to the office, transportation office? or-
It would come to our office. We'll give you a receipt. We'll deposit it with the treasurer of the metropolitan government.
We got a motion on the table first.
Is there a second?
I'll second.
All in favor.
All in favor?
Aye.
Motion passes.
I would encourage you to walk it down there Monday. Don't mail it, don't anything.
Should I ask my lawyer to walk it in?
I agree.
Only if you want to pay him to do it.
Today. Sure.
Mr. Fields, is there any other business?
No, I will go ahead and advise you, there are multiple complaints, very similar to what we've seen today, that have already been turned in for the July meeting. We did ask that the traffic study come back to you at the July meeting. I've not spoken with the consultant in the last couple of weeks, so I'm not sure if he's prepared to do that, but I suspect he probably is. So if you'd like to have that back in July, or if you'd like for me to roll that to August, I could certainly do that.
I think rolling into August sounds good if we're going to have a lengthy meeting as it is with the complaints.
What that particular meeting would be for is to follow up. One of the issues that came up was how much data did he collect from the industries. There are also questions about that. So the consultants have now offered and have spoken to many of them. I don't know that they've spoken to all of them because I don't know if they all responded. But he does have, the consultant team does have additional information that will they could share with you, and at that point you can begin. You could make it some that you could put on your own and actually put into place. Others you'd recommend to the Metro Council. Again, I can assure you that our attorney that covers multiple departments has a number of ordinance suggestions that we're going to be recommending to you to go to the Metro Council. So it's going to be a very busy several months. I would advise you that a bill regarding scooters as well as dockless bicycles is at the council on second reading. The commission will be, assuming it passes, will be given authority over the regulatory parts with respect to registering certificates of public convenience and necessity. Fortunately, there are no drivers involved and no people involved. It would be companies and compliance issues. So that will probably be sharing with that with you in the July meeting.
All right.
I have no other business to bring to the commission at this time.
Is there a motion to adjourn?
So moved.
All those in favor?
Aye.
Motion passes.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.